Do you know why I pulled you over tonight?
No, officer, I was just heading home from work.
You were swerving back there. Have you had anything to drink?
No, sir, I haven't had any alcohol at all.
The rain in the city that night wasn't a downpour, just a steady, freezing mist that made the neon signs bleed across the slick asphalt. Marcus pushed his glasses up the bridge of his nose, his eyes burning from staring at lines of code for the past 14 hours. He was a senior systems architect driving a 5-year-old mid-size sedan that he kept meticulously clean. All he wanted was his bed. He was exactly 3 miles from his apartment when the red and blue lights fractured the darkness in his rearview mirror. Marcus checked his speedometer. He was doing 33 in a 35 zone. He signaled, pulled over smoothly into a well-lit gas station parking lot, turned off the engine, placed his keys on the dashboard, and rested his hands firmly on the steering wheel. He had been taught the drill since he was a teenager. He breathed in the stale air of his car, telling himself it was just a broken taillight, just a random plate check. But as he watched the two figures approach in his side mirrors, their silhouettes framed by the harsh glare of the cruiser's spotlight, a cold knot tightened in his stomach. Officer Hayes tapped on the glass. Marcus rolled the window down, the freezing mist instantly biting at his face. Hayes leaned in close, a flashlight beam sweeping aggressively across Marcus's eyes, the back seat, and the passenger floorboard. Officer Miller stood a few feet back, his hand resting casually yet purposefully near his duty belt. Hayes asked Marcus if he knew why he had been pulled over. Marcus kept his voice even, polite, and completely neutral, replying that he did not. Hayes claimed Marcus had been swerving across the double yellow line for the past half-mile. Marcus knew this was physically impossible. He had been driving on a road with a raised concrete median for the last 20 blocks. He didn't argue. He simply offered his license, registration, and proof of insurance. As Hayes took the cards, he leaned in a fraction closer, narrowing his eyes. He asked Marcus how much he had to drink that night. Marcus explained that he had just finished a marathon shift managing a server migration at his tech firm, that he was exhausted, but that he had not consumed a drop of alcohol. He hadn't touched a drink in nearly 6 years. Hayes didn't blink. He just stared at Marcus, the silence stretching out, heavy and loaded with unspoken assumptions. Hayes turned to Miller, gave a subtle nod, and turned back to Marcus, instructing him to step out of the vehicle. Under the cold fluorescent lights of the gas station canopy, the reality of the situation began to shift from a minor annoyance to a profound violation. The legal threshold for a police officer to initiate a traffic stop is rooted in a concept called reasonable suspicion. Under the Fourth Amendment of the United States Constitution, citizens are protected from unreasonable searches and seizures. To pull a car over, an officer must have a specific, articulable reason to believe that a traffic violation or a crime has occurred. Swerving would certainly meet that standard. But Marcus hadn't swerved. The foundation of the stop was already a fiction, built on the dangerous combination of a quota-driven midnight shift and the implicit bias of looking at a black man in a quiet, affluent neighborhood at 2 in the morning and assuming he didn't belong. Out of the car, shivering in his thin windbreaker, Marcus was subjected to the standardized field sobriety test. Hayes instructed him to follow the tip of a pen with his eyes. This is the horizontal gaze nystagmus test, designed to detect the involuntary jerking of the eye that occurs when someone is intoxicated. Marcus stared at the pen, following it smoothly left and right. Hayes noted aloud that Marcus's eyes were jerking wildly. Marcus's heart began to hammer against his ribs. He realized with sudden terrifying clarity that the outcome of this test had been decided before he even opened his car door. Next came the walk and turn. 9 steps heel to toe along a painted parking line, pivot, and 9 steps back. Marcus focused entirely on his feet. He walked a perfectly straight line, his arms at his sides, counting out loud just as instructed. When he finished, he looked up, expecting to be handed his license. Instead, Miller smirked. Hayes pulled a pair of handcuffs from his belt. The metallic click echoed loudly in the quiet night. Hayes informed Marcus that he was being placed under arrest for driving under the influence. Marcus's voice broke slightly as he asked how that was possible, pleading with them to use a breathalyzer. He practically begged them to test his breath right there in the parking lot to prove his innocence. Hayes tightened the cuffs, perhaps a notch tighter than necessary, and informed Marcus that he smelled alcohol radiating from his pores, that his speech was slurred, and that his eyes were bloodshot and glassy. The boilerplate language of a DUI arrest report was being recited right to his face, a pre-written script overriding physical reality. A breathalyzer was never offered at the scene. They shoved him into the back of the cruiser, the hard plastic seat digging into his spine, his hands aching behind his back. As he watched his car being hooked up to a tow truck, panic set in. This wasn't a misunderstanding. This was a procedural machine grinding into motion, and he was caught in the gears. The holding cell of the precinct was a sensory nightmare of harsh smells, shouting voices, and profound isolation. They finally offered him a breathalyzer at the station, nearly 2 hours after the initial stop. Marcus blew a 0.00. The machine registered absolutely nothing. He let out a breath he felt he had been holding for hours, looking at the officer administering the test, expecting an apology, expecting a release form. Instead, the officer casually wrote something on a clipboard. The charge wasn't dropped. The narrative simply shifted. If it wasn't alcohol, they claimed, it had to be narcotics. They demanded a blood test. Marcus, exhausted, terrified of further aggravating the situation, and completely unaware of the intricate procedural traps being laid for him, hesitated. He asked if he could speak to a lawyer before a needle was put in his arm. In the eyes of the precinct and recorded in their logs, that hesitation was immediately classified as a refusal to submit. In many states, refusing a chemical test results in an automatic, immediate suspension of your driver's license, regardless of whether you are actually impaired. The officers knew this. They weaponized his confusion. They threw him back in the cell. He spent the night listening to the wails of other inmates, staring at the concrete ceiling, mentally calculating the damage. His car was impounded. He was going to miss a critical client meeting in the morning. His pristine record was stained. The psychological toll of knowing you did everything right, followed every rule, and were still stripped of your freedom began to settle heavily on his chest. When he was bailed out the next afternoon, blinking against the harsh daylight, Marcus was a different man. He hired a defense attorney named Sarah, a former public defender who knew the city's police department inside and out. Sitting in her cramped office, Marcus recounted the night. He explained the fabricated swerving, the perfectly executed sobriety tests, the 0 on the breathalyzer, and the manufactured refusal for the blood test. Sarah listened quietly, her pen tapping a rhythm on her legal pad. She didn't offer false hope or dramatic outrage. She offered a cold, clinical analysis of the law. She explained that to secure a conviction, or even to justify the arrest itself, the officers needed probable cause. Probable cause is a higher burden of proof than reasonable suspicion. It requires facts and circumstances that would lead a reasonable person to believe a crime has been committed. The police report, which she had already pulled, was a masterpiece of creative writing. It detailed Marcus's erratic driving, his stumbling gait, and his combative demeanor. It was a wall of legal justification designed to perfectly insulate the officers from any accusation of an unlawful arrest. If it was just Marcus's word against 2 sworn officers, Sarah told him bluntly, he would lose. The system is designed to defer to the badge. But Sarah was thorough. She filed discovery motions demanding every piece of evidence from that night. She wanted the Dashcam video from the cruiser. She wanted the bodycam footage from both officers. She wanted the dispatch logs, the GPS data from the police vehicle, and the calibration records for the breathalyzer. The city prosecutor's office dragged their feet, employing standard delay tactics. They claimed the Dashcam footage from the specific time of the stop was corrupted. They claimed Officer Miller's bodycam battery had died. These were common, frustrating hurdles that often broke the spirit and the bank accounts of defendants. But Sarah pushed back, threatening sanctions for the destruction of evidence. Eventually, the prosecutor's office produced the footage from Officer Hayes's bodycam. It was exactly as Marcus described, but visually, it was carefully curated. The camera only activated after Hayes was already at Marcus's window. It didn't show the driving. It didn't show the lack of a swerve. It showed a tense interaction, but the audio was strangely muffled during the crucial moments of the field sobriety test. It was a dead end. The criminal trial was approaching, and Marcus was facing a suspended license, massive fines, and a criminal record that would instantly trigger a termination clause in his employment contract. The pressure was suffocating. He stopped sleeping. He jumped every time a car drove past his apartment. The turning point did not come from a dramatic courtroom confession or a tearful apology. It came from a tedious, mind-numbing review of metadata, a procedural flaw that the officers had overlooked in their hubris. Sarah had subpoenaed the dispatch audio and the GPS data of the cruiser. While reviewing the timeline, she noticed a discrepancy. The officers had reported pulling Marcus over at 2:14 a.m., but the GPS showed their cruiser idling in a parking lot 2 blocks away from the route Marcus took until 2:12 a.m. before accelerating rapidly to intercept him. There was no way they had followed him for a half-mile to observe him swerving. They had simply seen him pass an intersection, gunned the engine to catch up, and hit the lights. But the actual silver bullet came from a completely different, almost mundane source. A commercial security camera on the corner of the intersection, owned by a 24-hour plumbing supply company, had a clear, wide-angle view of the street. Sarah's investigator had canvassed the area weeks ago and secured the footage just days before it was scheduled to auto-delete. The video was silent, black and white, and grainy, but it was undeniable. It showed Marcus's sedan driving perfectly, dead center in his lane, obeying the speed limit. It showed the police cruiser rocket out of a side street, aggressively pull up behind him, and activate its lights. The foundational lie of the entire encounter was exposed. There was no swerving. There was no reasonable suspicion. Therefore, under the doctrine of the fruit of the poisonous tree, every action the officers took after that illegal stop, the interrogation, the sobriety tests, the arrest, was a violation of Marcus's Fourth Amendment rights. Furthermore, during a deposition, Sarah managed to corner the precinct's IT technician regarding the corrupted dashcam footage. Under the threat of perjury, the technician admitted that the footage wasn't corrupted. It had been manually tagged as non-evidentiary and archived, a bureaucratic trick to keep it out of the primary discovery folder. When Sarah finally forced the release of that dashcam footage, it contained the audio that blew the case wide open. The microphone inside the cruiser had been recording the officers' conversation before they ever stepped out into the rain. The audio was clear. Officer Miller's voice crackled. "End of the month, man. We need one more traffic stat or the lieutenant is going to ride our asses." Officer Hayes replied, "Look at this guy creeping along. Probably a bartender going home or maybe just a nervous driver. Let's light him up and see what shakes out. If he's clean, we'll just say he clipped the line." They hadn't targeted him specifically because he was black. They had targeted him because he was convenient. But once they got to the window and saw a black man in a nice car, the implicit bias took the wheel. They assumed he couldn't possibly be a sober professional. They assumed his calm demeanor was insolence. They assumed they could railroad him and that society would blindly believe their paperwork over his protests. The criminal charges against Marcus were dropped the morning of the preliminary hearing. The prosecutor took one look at the security footage and the unarchived dashcam audio and realized their star witnesses had committed perjury on the police report. The dismissal was unceremonious. The judge banged a gavel, muttered a case number, and Marcus was free to go. There was no apology from the state. There was no immediate arrest of the officers for filing a false report. The criminal justice system simply spat him out, leaving him to clean up the wreckage of his life. But Marcus and Sarah weren't finished. They filed a federal civil rights lawsuit under 42 U.S.C. Section 1983, alleging false arrest, malicious prosecution, and violations of the Fourth and 14th Amendments. This is where the true, grinding reality of seeking justice in America unfolds. It is not swift. It is a war of attrition. The city's defense attorneys fought tooth and nail. They claimed qualified immunity for the officers, a legal doctrine that shields government officials from being sued for discretionary actions performed within their official capacity, unless their actions violated clearly established statutory or constitutional rights. The city argued that even if the officers were mistaken about the swerving, it was an honest mistake, not a constitutional violation. For 3 agonizing years, Marcus lived with the lawsuit hanging over his head. He was subjected to hours of hostile depositions where defense lawyers probed into his background, his medical history, and his character, desperately searching for anything to make him look less like a victim and more like a suspect. He spent thousands of dollars out of pocket. He lost his promotion at work because he was constantly distracted and missing days for legal proceedings. The trauma of the arrest lingered. He installed a dash cam in his own car, and his heart rate spiked every time a police cruiser fell in behind him in traffic. The turning point in the civil case came when Sarah successfully defeated the city's motion for summary judgment. A federal judge ruled that the video evidence and the interior cruiser audio were sufficient for a jury to conclude that the officers had acted with deliberate indifference to Marcus's constitutional rights, and therefore qualified immunity did not apply. The moment the judge ruled that the case would go to a jury trial, the city's calculus changed. They knew they could not put Officer Hayes and Officer Miller on the stand to explain away the audio recording. They knew a jury, seeing a completely innocent man forced through a humiliating and terrifying ordeal purely to satisfy a departmental quota and fueled by unchecked bias, would likely award catastrophic punitive damages. 2 weeks before the trial was set to begin, the city offered a settlement, $5.5 million. It was a staggering number, a headline-grabbing figure that would make the local news. The city council approved the payout quietly, burying it in a Friday afternoon press release about municipal expenditures. The settlement agreement included a strict non-disclosure clause regarding the city's admission of liability. Officially, the city admitted no wrongdoing. They were simply settling to avoid the cost and uncertainty of prolonged litigation. When the money finally hit Marcus's bank account, he sat at his kitchen table and stared at the screen. He was rich. He would never have to work a punishing 14-hour shift again if he didn't want to. But there was no joy in it. The payout felt like blood money, a financial bandage placed over a wound that fundamentally changed how he viewed the world and his place in it. The aftermath for the officers was equally anticlimactic. Officer Hayes took an early retirement with a full pension just before an internal affairs investigation could be completed. Officer Miller received a 30-day suspension and was quietly transferred to a desk job in the property and evidence room. Neither faced criminal charges for falsifying the police report. The system protected its own, passing the financial burden of their misconduct onto the taxpayers. The story of Marcus is a modern American tragedy wrapped in the sterile language of case law and civil procedure. It forces us to confront a deeply uncomfortable reality about the power we grant to the state and the fragility of our own civil liberties. When the word of an officer is treated as gospel, and the burden of proving innocence falls squarely on the shoulders of the accused, the scales of justice are inherently broken. The procedural safeguards written into the Constitution, reasonable suspicion, probable cause, protection against unreasonable search and seizure, are only as strong as the integrity of the people sworn to uphold them. If those individuals are willing to lie on a report to meet a quota or allow their unexamined biases to turn an innocent citizen into a suspect, then the law becomes nothing more than a weapon of convenience. Would you have the presence of mind, the financial resources, and the sheer endurance to fight a machine designed to presume your guilt? Or would you, like so many others, be forced to accept a plea deal just to get your life back? We must recognize that constitutional rights are not self-enforcing. They require constant, vigilant defense against those who find them inconvenient.